Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group. And today I have with me Ludka Zimochek, who's also one of the managing attorneys at the NPZ Law Group. And Ludka and I are going to be telling you a little bit about some of the issues which we're confronting lately, which are being brought sort of to the surface by virtue of you guys writing us, sending us emails, calling us. So we want to discuss issues that are important to you. As you know, our law firm has offices in New York, New Jersey. We also have an office in Indianapolis, Indiana, and we have a presence in Boston, and we also have a presence now in Chicago. So with that, what I'd like to do is to begin by opening this up to Ludka and asking Ludka, we have various individuals who have been contacting the office. And one of the interesting areas in the family-based classifications, and it comes to the surface when we're talking to our clients in our conference room or when they call and start asking about what is the impact if I'm being sponsored of my marrying someone, my having a spouse. And so I guess for the scenario that was provided to us, we have a U.S. citizen parent who is thinking about sponsoring their foreign national son or daughter. And the question comes up by the son or daughter, should I get married while that case is pending? And so obviously this is something which a tremendous number of people need to know because the process takes so long. Mm-hmm. And obviously life changes while you're in that process. So Ludka, what's the impact of a marriage on that process?
In that particular scenario, it would be fine because the parent, the U.S. citizen, is already a U.S. citizen, so it would be no problem. Once the son or daughter gets married, the case would go into F3 preference, so it would be no problem at all. The bigger problem is if the petitioner, the parent, is a green card holder. That would be a big problem because there is no category for married kids of green card holders. So whenever the child gets married, well,
son or daughter
who is
over
21
right?
gets married, the whole petition dies. There is no humanitarian reinstatement for that. There is nothing. So that's super important that if you're thinking about marriage, you need to consider maybe to wait until the parent becomes U.S. citizen.
And then to do it that way. Or I guess in the alternative, the other way to look at it is that the parent just never becomes a citizen, right?
But then the child cannot get married.
And then the child can't get married. So obviously the problem that we have here is that, again, the process takes a very, very long time. And because the process takes so long, things change in the interim. Obviously, many of the parents who we meet with want to know what the future holds for their kids, and many of them are actually in the process of dealing with arranged marriages, where yes, there's a process that they're moving toward having their children, being involved in arranged marriage. So the advice to them, obviously, is be careful because if you get married, it potentially impacts the family preference category and could potentially be the death knell of the case altogether.
Yeah, we've seen cases where the whole petition dies and then a new petition with a new priority date needs to be filed. And on the other hand, of course, there's a lot of fraud because let's say the son or daughter gets married and then they try to say, oh, this was just a religious marriage. That
exactly
brings up a different issue of fraud. So in order to avoid it, it's the best just to consult somebody, discuss it, talk about it with the family to see what's the best scenario for that particular family.
Exactly, and it kind of reminds me of a question that I got just in this week when somebody came in and they were, in fact, the kids were married, mm-hmm, and the person said, well, what if my brother gets a divorce? Then he's considered unmarried. Then can there be an adjustment filed?
Well, if they are unmarried, if they're in the F3 category as a married child, then you're right. If there is a divorce, then the case goes back to unmarried sons or daughters or F1, depending on what the if it's the U.S. citizen case or if it's a green card holder case.
Okay, and then that's okay?
That's okay.
Right.
Yeah.
Okay, so again, I think that the most important thing for everyone to realize is obviously marriages, changes of circumstances do potentially impact the case. Probably the best thing for everyone to do is, if you feel that this is a potentiality in your matter and your case has been filed, the I-130 has been filed, depending upon the family-based preference category, it's very important to consult with your immigration lawyer and to find out what the potential impact is going to be. So we just want to highlight that particular issue. Thank you very much for being with us, and we'll be back with some more interesting information soon to come. Thanks so much.
Thank you.